Cladding, and in particular composite panel cladding, has already been the source of significant litigation in New South Wales, including a couple of class actions that have been commenced, and it's been the subject of at least one significant decision in La Crosse that I understand Franco will discuss tonight. Franco has been pretty active in this space. He's well placed to address you on the topic tonight, having delivered a previous paper about a year ago. And I understand that tonight will be an update on developments in the year since he last spoke, including legislative developments since last year. Over to Franco.
Thank you, everyone, and welcome to Greenway. It was about a year ago, almost to the day, I understand, that I delivered a paper on cladding. At that time, it was more of a forecast. It was just bubbling along, and I saw it as a topic that was going to develop, and I made a prediction that it would be the new source of main building defects, and so it's proven. What I want to do tonight is to just have a quick recap, to take it forward, and I've called the presentation tonight Cladding Where to From Here. And to summarise, I think what is going to occur is burgeoning litigation of a major type, with building owners being bedevilled by commercial and forensic issues. We've had some assistance from Victoria in at least one forensic outcome of a case, which may provide some precedent for claims coming forward. And I'll deal with that, and I'll deal with some changes. Firstly, let's recap. That's what it looks like. It's everywhere. The facings are coated for weather resistance. They've been used for architectural look. They're relatively cheap. They're lightweight panels. They're easy to handle. They're easy to install, and they look good. They make sense, as I said last time, as a building product, and they make sense at every level except the level that we're going to be dealing with today. They've been prolific. They've been used everywhere, and you find them in the most amazing places. There are three well-known architectural buildings that employ this sort of product. Each of them have got aluminium composite cladding. The one at the top left-hand corner is the spaceship Earth in Orlando in Florida. The one below that is the very well-known Guggenheim Museum in Bilbao, which is absolutely coated with the stuff. And the one at the right is the German National Library in Leipzig. So you find it everywhere. That's what it's made out of. I dealt with that in a more technical way in the last occasion. It consists essentially of plastic. You can call it plastic. It's got other names, and the names sometimes it has, and the different types of substance are in the middle of that particular slide. Mineral fibre doesn't burn, and that's the safe stuff. The other stuff is pretty harmful, and I'll come to that. And the reason it burns is it looks like that on the right. Its molecular structure is carbon, string of carbon molecules with hydrogen atoms hanging off them. And depending on the number of hydrogen atoms that hang off them, you either get rigid plastic, so the more densely packed it is, you get rigidity, and the less hydrogen, you get flexible. So the stuff that you wrap your sandwiches in has got less hydrogen coming off the carbon, but what we want, and what we've wanted over the 90s and 80s when the stuff was used, is a rigid type plastic, and the rigidity has caused it to be dense. That gives you a little reason as to why the stuff is really bad. So the combustibility ratio is a ratio that fire engineers use in order to illustrate how flammable something is. And so it's a simple ratio, the amount of heat released when it's burnt over the amount of heat it takes to ignite it. So wood, for example, has got a combustibility ratio of 3. The dense stuff, the dense plastic stuff that we're talking about, has a combustibility ratio of 25, which means it generates 25 times more heat than it actually takes to burn. So it makes obvious logical sense that if a panel burns and it's next to a panel, that panel will burn as well. There's about, depending on what you read, how prolific is this stuff? Well, the most current research seems to suggest perhaps 1,000 to 2,000 buildings have combustible aluminium composite cladding on the outside. And if that's right, it's a really significant problem. It will be made more significant as a result of what's happened in the legislative field. So one of the reasons it spreads quickly is because of its combustibility ratio, but the other reason it spreads quickly and the reason it's pretty nasty stuff on the outside of a building is because, firstly, if it's added as a cladding or suspended from the body of a building, there's usually a gap, and that gap between the composite panel, which is the sandwich of plastic, acts as a chimney, and that's what happened in the Grenfell Towers. That's the configuration there, which comes from the slides I used last year to indicate what it was like at Grenfell. Also, the top hat might have another backing or insulation behind it, so that creates a different problem. And it's not only the polyethylene that causes a problem, it's also the aluminium itself. And what happens with this stuff is when it burns, it goes from rigid to liquid, and so it drips. And the aluminium is a good conductor of heat. It heats up the polyethylene, and it adds to the spreadability of the fire. They're two of the most recent, the two of the Australian, well-known Australian examples. The Lacrosse building is the one at the left. You get the idea. And the one on the right was the Neo building, which also, let's go back, burnt this year. And that fire occurred over 5 stories, and that building was in Spencer Street. As it happened, L.U. Simon built both of them. L.U. Simon was the builder who built the Lacrosse building and famously said, denying negligence, that the reason it wasn't negligent was because he'd been using this stuff for 40 years, and thus, and remarkably, as you learned, L.U. Simon was found not negligent. I suppose I should try and summarise how did we get here. It's a very long, convoluted and involved story. Last time I indicated that one of the reasons that this problem has developed at the stage where we find ourselves is that there were ambiguities in the building code that were exploited. Whether they were understood or not is a different matter, that they were exploited by developers and poorly understood. Let me just say that the stuff seems to have been developed by a joint venture of Bauer and some other company, Swiss company, in 1969. It was patented in 1971. The patent ran out in 1991, and since that time there have been about 200 manufacturers that have entered the market. It was originally marketed under the brand name Alucobond, and Alucobond is has been used pretty extensively in buildings here. By the 1990s, it was gaining a level of acceptance, and the Australasian construction market was using it, and it was assisted by performance requirements and design and construct contracts, and the poor understanding as to what the building codes required by way of verification. And I have my reading glasses on, so I can't really see the screen, but I think it's the screen that tells you what the last regulatory statement in relation to the development of this problem. What you have there is, I think, yes, it's the Australian Building Control Board report. That they've issued a few reports on this stuff, and the Australian Building Control Board is a joint initiative of the federal government and the New South Wales government in consultation with industry representatives to try and deal with various issues, and they've dealt with cladding in a couple of places. This particular place is where they tried to summarise what people thought had been the derivation of the problem which bedevils the industry now. And you'll see the last bullet point is what the industry believes, that namely that the regulators simply didn't enforce what they now say were the relevant regulations. The surveyors who have made various submissions to Senate inquiries and so on, that's the building surveyors, certifiers, have essentially said don't blame us because the Building Code of Australia was fairly ambiguous in relation to the use of cladding as an addition to the outside of a building, and they've now tightened it up because they issued, the board issued at the same time as they issued this paper in 2016, a paper which essentially clarified how the relevant provisions of the NCC were to be interpreted, because obviously of the uncertainty in the various submissions that were being received about the fact that it was ambiguous. So that tells you briefly how we've come here. And the second, this point here, substitution is pretty important because under design and construct contracts where cladding has been specified, without turning one's attention to what type of cladding, design and construct contractors have sometimes gone offshore for the purposes of acquiring it. Most of this stuff is manufactured in China and have used it on the basis that it's value engineering, in other words, reducing the cost of the building by using a substitute product. It's not intended to be a dishonest substitution, it's rather the largesse which some builders have used in relation to construing design and construct obligations. I said I'd come back to Lacrosse. Richard's mentioned the decision. I was told by Alistair Little that his cousin actually decided it. No one's actually ever read it. It's 225 pages of decision. I'll try and summarise it as best I can. They're the parties. It was developed by Pan Urban. It was a design and construct arrangement. Pan Urban engaged the contractors. There was an architect. You see it's on the slide. There was a fire engineer. There was a building surveyor, a certifier. And there were two individuals named at the bottom. They owned Unit 805. And Mr. Jean-Francois Goubitard was a French guy who was here, I think, on a working holiday. And he was living in the apartment. He was living there with 6 other people. And in this cosy arrangement, he came home from work, put down his backpack, went out on the balcony and had a cigarette. He stubbed it out in a plastic bucket, which is used as a ashtray. and that was sitting on a timber top balcony table. About 2 o'clock in the morning, the smoke detector in the hallway went off. 6 minutes later, the fire brigade arrived, and in 6 minutes the fire was travelling rapidly up the external wall of the cladding. It spread onto the balcony at each level, and it had already climbed to level 14 6 minutes after it started, and 6 minutes after that it reached the roof. The damage was very substantial, and the losses were quantified for the purpose of the court case at $12 million plus. There were 400 people living in that building, and it was sprinkled, which was not, of course, what Grenfell had. The fire brigade managed to get all 400 out, and there was no injury. So what happened is that there were 221 claimants. It was a stratum lot. It was a mixed-use building, so there were stratum lots. Each of the owners' corporations were claimant, as were each of the lot owners. The case was essentially contractual. There's a reason why they did not plead negligence against L.U. Simon. L.U. Simon, they didn't want to apportion the liability against L.U. Simon, so they relied on the claim being contractual, and they, as the slide shows, sued under Section 9 of the Domestic Building Contracts Act, and they're the four main heads of breach that you can see on that slide. They also alleged that because the stuff was imported from China and the goods were defective, it was defective goods, and the builder should have been considered a deemed manufacturer, and they sought liability under the Australian consumer law for that. Now, the pleading, as I had it, had claims against Gardner. Mr. Galanos was an employee of Gardner, the building surveyor, and the reason he was joined is because in Victoria, the building surveyor, as I think here, has to be a person. Gardner had the retainer, and Gardner arranged for its employee Galanos to actually do the surveying and issue the certificates. And you can see the heads of negligence claimed. This became relevant because what happened is Simon joined and issued cross-claims against the various consultants. Under the terms of the novation, of course, L.U. Simon had a contractual relationship with each of the consultants and sued each of them for breach of their particular retainers, which were retained to them, and also negligence. But insofar as there was a negligence claim in the pleading, that was the negligence claim against Gardner and the employee. The architect was also sued for negligent provision of architectural services, and there was a stage where it did work for Pan Urban, as did Gardner, and then after the novation did work by Simon. Essentially, the negligence which they contended was negligence carried out during the stage of the novation when L.U. Simon was actually had the contractual relationship with each of the consultants. And what happened is that there was a sample of the panel that was provided by the architect for approval. The superintendent under the building contract, who was one of the parties I think I should have mentioned, Property Development Solutions, Victoria Proprietary Limited. That was the superintendent under the design and construct contract. After the presentation of the panel, it was approved and on it went. The fire engineer prepared a fire engineering report which provided an alternative solution and said that the alternative solution complied with all the requirements of the BCA requirements, and the owners corporation and the claimants maintain the same breaches as L.U. Simon maintained in the cross-claim. The superintendent had the same assertion of negligence made against it, namely negligent approval of the cladding that was used, and that was settled before verdict. Poor Mr. Kim was the owner of Unit 805. He was joined because they said it was negligent for him to keep crap on the balcony, and Mr. Gubita was sued because he caused the fire. And they were joined for apportionment purposes. Mr. Gubita didn't appear. I assumed he'd left and gone back to France and wasn't interested in the outcome. And so that was how it was set. So let's go through what happened. Simon was found liable under the implied warranties. Implied warranties under Section 9 of the Domestic Building Act down in Victoria are largely the same as 18B. The only difference is that in Victoria, Section 9 warranties are actually made assignable in the sense that the subsequent owner has the right to simply step into the shoes of the original developer for the purposes of suing on the contract. So Simon breached the implied warranties, but amazingly was found not to be negligent because the judge essentially found that a builder in L.U. Simon's position wouldn't have known any better, having regard to what was known about the use of this product and having regard to the fact that it had been approved, the panel had been submitted. There was an issue in relation to the specification. I won't bore you with that, but if you read the decision, there was a real issue as to how the specification was drawn. And as I say, the manner in which it was pleaded was quite deliberate because the intention of the owners corporation and the claimants was to avoid an imported failure to avoid a finding of failure to take reasonable care and thus an apportionment. So Simon was found 100% liable for the losses on the basis of the breach of the warranties. And as to the material not being good and suitable and not complying with the BCA requirements. So having mounted it didn't really mount a substantive defence to this particular allegation and instead sued for contribution from each of the consultants. Part and parcel of perhaps why L.U. Simon were not found negligent in the sense of the apportionment claims is because the allegations of negligence were pretty vague in the pleadings, and the Simon defence essentially was the Alucabest literature at the time indicated that the product was suitable, and a builder, being merely a builder, would not have known any better than what the literature was on the subject. And importantly, and I think for the purposes of any negligence action, there was a finding in this case that in 2011, when this building was being designed, it was, I think the occupation certificate, as I think the earlier slide showed, was in 2012. But at the time the building was being designed, there was poor understanding among building professionals, excluding fire engineers. His Honour thought fire engineers should know better, of the fire risks associated with aluminium composite panelling. And having regard to the overall cohort of building professionals, there was no reason, His Honour thought, to expect that building firms like L.U. Simon would have a superior understanding to, for example, architects and building surveyors. and His Honour said, in fact, the contrary was true. Now before I leave that, let's just talk about Gardner. Now the issues surrounding building surveyors in this sort of area are indeed complex, and they probably, as a result of New South Wales Court of Appeal decisions here, may not be quite the same as Victorian precedents have established in relation to building surveyors. And building surveyors have got a statutory obligation in any event. The Gardner Group was found liable because ultimately His Honour found that they should have known better in approving the design and documentation. In essence, the documentation was a little ambiguous as to the type of product, and His Honour considered that they should not have given a building permit having regard to the state of documentation, and knowing about the Elukabest, they should not have approved the building. Similarly for Ellenberg Fraser were pinged and found negligent in that proportion as a concurrent wrongdoer, because they should have known better in relation to the approval of the panel which they presented and allowed to be put on their building, and the liability of the fire engineer was based on the fact that it had superior knowledge and should not have expressed an opinion that the alternate solution complied with the BCA because it used panelling which did not. And interestingly, Mr. Gupta, who caused the fire, who didn't take part in it, His Honour found that really the burning didn't cause the whole of the actual fire. It was not foreseeable that someone smoking on a balcony would cause fire to the whole of the building as a result of the cigarette, and His Honour found that the real and substantial cause of the loss was the use of the unsuitable product in the way that it was used. That slide talks about the reaction. There have been a couple of amendments. Let's just deal with them. I think you've got the two regulations. One is the regulation and one is there are three. Let's deal with each of them in turn. If you turn to the Environmental Planning and Assessment Amendment, identification of buildings with external combustible cladding regulation, you'll see Division 7C. I'll just take a moment to have a look at it. Oh, and I should say something about the verdict. His Honour, there's $12 million claimed. $4 million of that odd was agreed, and there were fights and negotiations in relation to the quantum. Interestingly, as part of that, His Honour allowed the increased amount of insurance premium in that case. That was quite a hefty increase. And insurance is one of the major problems that has developed since I last spoke to you. I'll come to that at the end, but just in that case, as a result of the cladding and the fire, the insurance premium went up by $700,000, and that was part of the verdict which was allowed. In essence, there was quite a large whack for the work that had to be done, but also there were losses yet to be quantified and the subject of negotiation and so on in relation to the loss of rent and so on. Let's go back to this particular slide. So there are two things that happened. Firstly, Division 7C was introduced, which required building owners to provide registration details of a building with its cladding. The second regulation if you turn to, for example, clause 2.50b, you'll get the gist of what's there. You'll see that now, for the purposes of development which includes cladding isn't to be carried out on any building which is other than the house, which is a 1 or 2 story house. So it also changes the planning law, but the principal thing that occurred in August last year, on the 15th of August last year, was the product was banned. And it was banned under this piece of legislation. So it's up on the screen. So it's the Building Products Safety Act, which allows the Commissioner of Fair Trading to ban any product on condition and on terms, and I've set out on that shot how it operates. So what happened on the 15th of August 2018, the use of aluminium composite panels with a core which comprised more than 30% polyethylene in any external cladding, in any external wall, any external installation, any facade, any rendered facade in various buildings was in fact banned. The ban was expressed in that way because under the former way in which some people read the Building Code of Australia provisions, if the outside of a building was 2R fire rated, made of masonry, made of cement, people considered it didn't matter because they weren't really familiar with how this composite cladding spread fire, to just attach it as an architectural feature. And some took the view that the Building Code of Australia, on its proper construction, allowed, so long as it's not load-bearing, so long as it's not a wall, and it was a lining with an architectural feature to it, didn't have to be 2R fire rated, and it could use different product. It's now been made absolutely plain that it cannot be used in that way. The ban operates retrospectively. It applies to buildings constructed before the ban came into force. I've arranged to provide you with the building classifications memorandum from the ABCB. The reason I've asked for that to be printed out is that the way it operates is that Class 2, 3 and 9 buildings, and you'll see how they're classified, if they have a rise of more than 3 stories, Type A, they're banned. In the Class 5, 6, 7 and 8 building with a rise in 4 or more stories, banned. In a Class 2, 3 and 9 building with a rise of more than 2 stories is banned. In a Class 5, 6, 7 and 8 building with a rise in more than 3 stories is banned. So in essence, no matter what class, it's going to be over 4 stories, you're not going to be able to use it. There are some exemptions. There are 2 exemptions. The first exemption relates to combustibility which is prescribed, and that relates to material which does not spread fire and has been properly tested for that purpose. And it's been properly tested under the relevant standards. There's huge penalties if you use it, up to $1 million, 1.1 million for contravening the ban. And if you put it on, you get an additional penalty of $110,000 a day for every day it remains on the building. So that indicates that they really mean business when they say banned, it's banned. And it's also, if that's not enough, it also relates to criminal liability for the executives who are behind the development company that might, or the builder that might have chosen to use the product. There's 2 years imprisonment if you're an individual, and if you're an individual and do it, then it's not only 2 years imprisonment, it's $220,000 penalty and $44,000 a day while it continues. The ban applies even if, when it was put up, it complied. Even if you can show that the panelling that you put on complied with the relevant NCC provisions, it's still banned. And the Commissioner said that the NCC is not sufficient to regulate building products and can't be relied upon in isolation to manage the risk of aluminium composite panels. And of course, those transactional lawyers that are here presents particular difficulties if you're acquiring an office building or a relevant class building where the product's been retrospectively banned, as to the searches and inquiries and so on that you have to carry out. That is the registration issue. The registration should have been in February, so there was every owner that had a non-compliant cladding was required to notify for registration on the portal, New South Wales portal, by February, and any new building has to have it registered within 4 months of occupation. And there's a checklist. Essentially, you go down that checklist, and if you tick any of those boxes, then it needs to be registered, or needed to be registered, and if it's a new building, it has to be registered. I've put on that slide the various registration dates. So there's now a register, and the register will eventually, and this is now what's happening, result in receipt of a notice requiring you to take action. I'll come to that in a moment in respect of some particular matters in which I've been involved. And that task force, the Fire Safety and External Wall Cladding Task Force audit has identified, I refer to about 1,000 buildings. I think their number is 2,280 sites. Of those, 417 buildings require further assessment as a high priority because they're cladding with potential fire risks. 222 of those 417 are residential, and 85 are high-rise, more than 8 stories. And notices are now, I think, being received which require the owners to take action. Let me, in the short time I have available, I could deal with various ways in which other states have dealt with this, but essentially they're all moving along similar lines. And that is to require action to be taken in respect of all combustible cladding which exists on buildings. The eventual result of this, I think, is going to be that buildings are going to be largely buildings, if you don't take the action, buildings with combustible product, because of the dramatic view that when these buildings go up, they burn in a dramatic way, and they burn with quite a lot of damage. I was just saying to Alistair that a couple of weeks ago I was asked to go to Brisbane for the purposes of negotiating on behalf of a fairly substantial building owner on insurance. This was a very high building. It had non-compliant product but wasn't clad with it. It used it truly as an architectural feature in the sense that the cladding was used for colour. It had no large expanse. It was used as vertical elements for decorative purposes. There were horizontal exposed slab edges which had been finished rather than a nice finish, had been coated with or dressed with cladding for the purposes of making it look neat. It's a good looking building. And a number of insurers had looked at it, and the insurer that had insured the premises for public liability and fire upped the premium from memory by about 6 or 7 times. And that's the sort of hit I think that people are experiencing universally in this area. And there's no sense really of reasonableness in trying to deal with this issue. The insurers see the fires that have occurred around the world in buildings, and they don't really understand, the people that rate this risk don't really understand how you can mitigate this risk. If you think about it, if this combustible cladding has no combustion source, and this particular building had cladding at ground level, and otherwise the cladding was high up on the building. And so the building owner said, what we'll do is we'll just remove all the cladding. We'll remove all the cladding so that if a car runs into the building, or if someone lights garbage at the bottom, it won't burn. There'll be no combustible source. The building had no balconies. So it was not like Lacrosse where someone could go onto the balcony and actually get to the cladding. It was suspended at the end of exposed slabs. And you would have thought, if you've got a fire engineer who we had with us, the fire engineer said, look, what we'll do is we'll put additional sprinklers on the outside every 2 stories. So if by some unknown ignition source the cladding should burn, why we're going to limit the damage to no more than 2 stories, you would have thought that you would have had some mitigation or some way in which the insurer would say, yeah, well, that makes sense, we'll mitigate because you've more or less made sure that it won't go for more than 2 stories. I can indicate it was very hard yakka trying to convince the insurer. And simply, when you think about it, how can cladding in the air, even though it's highly flammable, burn? Lightning strike might be the only potential source. And so the current tendency in the insurance market is not to want to take this risk on. And I think that if the legislatures don't force, eventually the insurers are going to force by virtue of the way they're writing premiums for this stuff to be removed. At the end of the day, it's a fairly interesting time. If you look at the litigation down in Victoria and you look at what's happened here, there is an avenue for owners. And the last piece of legislation I want to take you to in the time, which is about time now, is that right? Is the Home Building Amendment Cladding Regulation 2018. If you have a look at that, what this does is it modifies the definition of major defect in home building warranty claims, and you'll see 69 capital A. For the purposes of paragraph B of the definition of major defects in section 18E4 of the Act, if the external cladding of a building causes or is likely to cause a threat to the safety of any occupants of the building, if a fire occurs in the building, that defect is described as a major defect. So they've made it a major defect, and you'll see that the clause applies in respect of a breach of statutory warranty only if the warranty period starts on before the commencement of this clause, or if the warranty period started before the commencement of the clause and an action could be commenced. So what this reflects is a tightening, building development control changes, audits and orders, all headed one way, and all of the lawyers in this room will be, without any question. Last time I spoke, I thought it was coming. Not only has it come, but it is like mesothelioma or asbestosis at its beginning, and it will be growing. And practitioners who practice in this area, I think, would be well served being on top of this particular issue. Thank you.
Any questions?
Hi, I can't see who I've got my reading glasses.
Sorry, Laura Dale.
Hello, Laura. How are you?
Hi. In terms of cladding, obviously there's quite a few fire experts out there that are producing reports saying whether or not products are compliant and suggesting a recommended scope. Some of those scopes...
As an alternative solution?
Yeah, some of those scopes are an alternative solution.
Yeah. Which is what you would do first off before removing it.
Sure, of course. But in the face of a complete product ban for ACP that has a core of 30% or more, how can it reasonably be sustained that you can have an alternate solution in the face of increased insurance premiums, reduced insurance periods? So some of the buildings we find have gone from a year for insurance down to 6 months. How can an alternate solution be a viable option in that situation?
Good question. It probably can't. But nevertheless, as I understand it, in New South Wales they are accepting alternate solutions to make them compliant. So I think the issue is, although it's retrospectively banned, if at the end of the day you can satisfy the government not to issue with an order, and what usually happens is the order issues and then you try and negotiate with the regulator as to whether or not it has to be removed. And if the regulator is satisfied that it doesn't have to be removed, then I think everyone is satisfied that it doesn't comply, that it complies, and it's not an untoward, even though not strictly compliant, resolution. Because at the end of the day, this stuff costs a lot of money to remove. And if owners have got no recourse except themselves for a large... I think the estimate in La Crosse, when they were talking about its removal, was something like $15,000 per apartment. Now, I don't know whether that's still currently the estimate, but it's a lot of money, and particularly if you've got a high-rise building where it's going to be scaffolded. It causes all sorts of issues. So I think, let me just say, if I go back to this, I think this is important, and it may have been lost in the speed in which I was doing it. None of the state governments have put up their hands yet, because at the end of the day, councils allowed this. The government allowed this. The Building Code of Australia was arguably terribly drafted and was ambiguous. And I'm pretty confident that the government itself knows that. And so they've got a huge problem on their hands, and they're not totally blameless. The building surveyors, I think, have got it right when they say they carried the brunt. And if you think about this, and you go back to 2011 or 2010, a building surveyor is not a fire engineer. He or she is there for the purposes of ensuring the building complies. There's a specification for aluminium composite cladding. People poorly understood what you had to produce for the purposes of satisfying someone that in fact it was non-combustible or was safe as a building product, particularly in circumstances where if you went to the various sites, the manufacturers were representing that in fact it was suitable for use. Now if you go to the sites, of course, you only find them, if you go to the Alucobond site, I think you'll find that Alucobond only have the mineral core composite cladding panel. And so I'm quite sympathetic to a building surveyor. In fact, I indicated last time, and I was actually asked to advise in respect of a building 2015 came to my attention. A building was being built with a composite cladding. It happened after lacrosse, and the fire brigade here for the first time queried an alternative solution in respect of a fire exit with cladding on the top. And I was asked to advise as to whether or not it had to be 2-hour fire rated as a system. And I formed the view on a proper reading of the requirements of the code that it did, and it gave advice accordingly, and it was taken to Singapore and tested. But up until that stage, even the fire engineer that was engaged for the purposes of preparing the alternate solution, and this is a fire engineer, that's the business of fire engineering, considered that it was a cladding and it did not have to have 2-hour fire rating as long as it complied with combustible material in the sense that allowed under the BCA, and it was wrong. So, you know, I'm sympathetic to this view. Sorry.
Tony Chow from James Russell Lawyers as well. On the point that you and Laura have said, a few things. One, the lacrosse occurred before Grenfell, and none of this was really being focused and happening until Grenfell happened. I mean, Neo was built well after lacrosse, so it's not like they didn't know about it. Yeah. And in the UK, the government is fronting for the rectification. Yeah. Yeah. And it's not that people didn't know about it, they knew about it, but as you said, the drafting of the Act was poorly done, and they were doing what's cheapest and best for them. And like Lou Simon says, you've been using it for 40 years.
Yeah.
So how are people going to afford the rectification? Because most people, if they're owner-occupier, are spending every cent they can to just get into the place in the first place because they're not cheap. And then when you get asked for a special levy between 20,000 to 90,000, how do they afford it? Other than
they can't.
Bankrupt, because they can't sell the property. The register is not available to the public. So when you want a prospective purchaser, unless you know and understand what even cladding is or even looks like, you might be purchasing into something that ultimately you can't afford, because owners, corporations and strata managers are not informing their tenants and prospective buyers, and we as lawyers don't have access to these registers.
Have a look at the second bullet point. That means that this is Weedle words for saying what was intended in the BCA was diminished, i.e. they didn't really apply it, either because they knew and went around it. Look at the last one, differing interpretations. Let me just tell you, building regulations should never have differing interpretations. And this is what the building surveyors were saying. I mean, you draft it like that. I mean, on its face, it looks like we could do what we did, and now you're blaming us in circumstances where you allowed it to happen. And so I think at the end of the day, there's much to be said about the fact that the government at some stage is going to have to man up. But nowhere, in no state, in Australia has any of the regulators actually owned the problem. They say it's the owner's fault. Not fault, but it's the owner's responsibility, because if no one else is liable, if you're out of time or the warranties don't apply, the building is old and it's your problem. You've got to fix it because it's not safe, and more importantly, you won't be able to insure it, and the insurance is going to cost you heaps. You're going to be driven to it.
Because the notices have gone out for the high risk ones.
Have you received some? Your client? You will.
And that's the issue. That
But
there's
that's
going to be a time where they're going to turn around and say, look, our tenants, our lot owners can't afford it, right? They can't get and the insurance, because they're just pulling figures out of the air because they don't know how to deal with it. That's
the insurers.
Yeah.
Oh yeah. When I tried to inquire, and I had the opportunity of speaking to the underwriter who was rating the building, you realise that underwriters don't rate; they rate it by gut. They just say, "Oh, look, this stuff burns," and they just take a shot. They have no idea.
That's exactly what's happening, and so you're gonna find a lot of people turning around saying, well, I can't afford it, and I can't sell it, and I can't fix it, and we're incurring fines on a daily basis.
Yeah. I don't know where it's going to. I predicted it was going to be a problem. That prediction was right. I'm going to predict it's going to be a bigger problem, and that prediction will also be right. You'll see a lot of litigation in this area, trust me. And the L.U. Simon decision gives some comfort to building owners, assuming the High Court decision in multiplex is ultimately set aside, because obviously in New South Wales you've got no right of action in negligence against anyone.
And as a certifier, why would I want to certify a large high-rise building when I'm the small fish getting the benefit, where the developer is, receiving the biggest profit, and for 20,000-30,000 on a very high-rise building, I'm taking on a maximum risk as a certifier.
Just to go back to Laura's question, what you'll find is the fire engineer who provides the alternate solution will not guarantee the alternate solution. I can assure you about that.